Welcome to Your Rights, Your Voice. Family Law Clarity with Ellie Sweeney.
Hey everybody, welcome back to an all-new episode of Your Rights, Your Voice, Family Law Clarity with Ellie Sweeney. I'm your host, Mike Leon. Ellie's a California family law attorney serving clients across Los Angeles and Ventura counties. She represents clients in divorce, custody, child support, and other family law disputes, bringing clarity and strategy to every stage of the process. And in today's episode, we're talking about what really happens in family court trial, what to expect, how to prepare, and what the experience is like for clients. Ellie, good to see you. Let's get into the first question here. Could you explain what a family court trial is and how it differs from hearings or settlement conferences?
Hi, Mike. Thank you for having me. Family court trials. Number one thing that a lot of people don't know, you do not get jury in family court. It is what we call a bench trial, which means there's only a judge who will decide your case. But outside of that, it is a process that is pretty much the same like any other trial, where each party would be presenting evidence and testify and so forth. So how it's different from, for example, settlement conference. Settlement conferences are done sometimes in court, sometimes outside of court, but they are confidential and they are really made for the purpose of trying to get the parties to settle some issues, if not all the issues. It is typically done very informally, although if you are doing them in court, they will still require that you have all of your paperwork prepared ahead of time, almost as if you're ready to go to trial. Because if you're doing a settlement conference, you should know what you're asking for, and you should have the ability to show the judge who's doing the settlement what your evidence would be, because that's how they evaluate it. In Los Angeles County, most of the time, we would have a different judge do a settlement conference because they don't want the same judge to be the judge who's doing your trial. So that it's just because they feel that judge, she should not know what you were willing to settle for necessarily if you do end up going to trial. And then what is a regular hearing? A regular hearing is usually done during the pending divorce case, where you file just for one or two issues that you want the court to help you get in order. It can be perhaps relating to custody. You're asking the court, hey, we need to have some kind of schedule in place because we don't have one and we don't know what to do. It can be for support because maybe one party is in urgent need for support. They're not going to wait for trial to do that. So you file a motion and you have a hearing on that motion, and the courts basically allocate about 20 to 30 minutes for that hearing. They'll have a calendar of about 10 to 20 cases for one day that they need to hear, and those are for hearings. But when you have a trial, they'll schedule that very separately. They will give you your time, and that is a whole different process, and it is with presenting evidence, testifying, and so forth.
So, Ellie, in California, which family law matters usually go to trial? And do some cases go that far? I mean, they go that far, excuse me, but others get resolved earlier. Is that the case?
Some get resolved earlier. There's a huge variety of cases when you think about family court. There's sometimes parties who never even end up going to court at all. There are parties who would come to me and say, we already know what we want. We have an agreement. We just need your help to help us with the paperwork to file petition for divorce and bring us to final judgment. Beautiful. I mean, when people are able to do that, it's a wonderful thing. Sometimes they'll have different disputes. For example, it can be support. They cannot reach an agreement on support, or it can be custody. And then they'll need a court order for that. But perhaps they get that along the pendency of divorce. Just like I said earlier, you can get those orders, and then maybe then they're able to resolve everything else and they still get the final judgment and not go to trial. Sometimes they're able to resolve a variety of things up front, but maybe there's just one thing they cannot resolve. And perhaps it's who is to keep the house. They both want to keep the house. And they may end up going to trial over that and have to present evidence who is to keep the house. But sometimes it's the entire case. Sometimes you can have everything in trial, and it can be a lengthy process. So it really, really depends. I mean, there's anything from the most simple, basic case to the one that can last years and have many days in court for trials.
Wow. So you mentioned before about the differences between family court and a regular trial, let's say for all intent and purpose. Who's permitted to be in the courtroom? And I'm assuming it's not open to the public, or is it more of a private matter?
Actually, it's open to the public, and anyone is allowed to be present. And if you have a court reporter, that record is available to public as well, and any filings that were done in court. In the past, there were certain cases in family court that were not public. Those were what we call parentage cases, when couples were not married. And so they're just filing for custody and support, for example. But the courts changed that, so those are accessible now as well. But who is not allowed to be? Children under the age of 18 should not be in family court. As we can all understand, they're very serious issues that are being heard and presented. Um, and also any potential witnesses. So if you're going to have a witness, then they cannot be present while your client is testifying, because we don't want them to be influenced by that testimony, especially if they're percipient witness of something that happened and so forth. So those are the only ones who would not be present. But other than that, even I'm sure you've heard of this, but even news agencies can file a request to actually be present during trials in court, which can really become messy for a courtroom, but they do have the right to do that.
I can imagine. And the person who's going to oversee the messiness potentially is the judge. So I'd love for you to talk about the judge's role in family law trial, how that's different from in other cases.
I feel our judges who do family law are absolutely fantastic, and they have an incredibly difficult job in front of them. Um, and it is not just about what they're going to rule, it is about how they're going to handle these proceedings. Because think about it, it's a trial or it's a hearing. You have in front of you both parties. This is also different when in civil cases, a lot of times the parties are not needed to be present during the hearing. Here, you always need to have party present. So you have the parties present, then you have their attorneys. So sometimes the attorneys are arguing, sometimes the parties may be arguing, and the judge has to sort of put everything under control and make sure that everybody's behaving properly so that they can present their case. There's bailiff always in court, and bailiffs are also helpful, I find, during trial, during these proceedings, because they can step in and they can tell somebody, please lower your voice. They can also step in, and you feel a little bit protected because these bailiffs are standing there and they do have a gun. And if you don't feel safe, for example, during restraining order proceedings, you can tell the bailiff, hey, can you please ask the other party to just stay here so I can leave first and they cannot follow me, and they will do that. But again, going back to judges, they have difficult job ahead of them, but they do what they can, and I believe every judge I've been in front of is doing a fantastic job in managing their cases, making sure that everybody's being heard, and just to be able to make the proper ruling in the end, because at the end of the day, that is what their job is, and they they will take everything into consideration.
Yeah. Ellie, let me ask you, do clients of yours or clients just in general usually have to testify in a family law trial?
Most of the time, yes, yes. Um, because at the end of the day, I'm presenting something that is related to things they know, not I. So whether it's about custody and they want to talk about what the relationship is between them and their children, or whether it's about a property and why they want to keep it, they would need to present that testimony. A lot of times we will put it in writing ahead of time. I've had some phenomenal judges lately who would suggest, just to sort of, save us some time, to put the entire testimony in a declaration ahead of time, subject to cross, meaning we present the testimony in our declaration, and then my client would still have to sit there and be and respond to questions by the other attorney, because they have the right to question them, and that is called cross-examination. So even then, they will need to testify. It just may save us some time. But I'm trying to remember if I had any trial where I didn't have my client testify. And I'm not sure that I did. I think they pretty much always have to testify.
Yeah. Well, let's ask you another question, and I want you to see if you can remember this. How long does a family trial usually take? 'Cause I think you alluded to it earlier. There's timelines that could vary depending upon the trial itself. But what factors affect that timeline?
So it'll depend on number of issues that need to be resolved in trial, and then the amount of evidence that each party plans to present, and the number of witnesses who are going to need to be heard. So what we do in family court, we will have a trial setting conference scheduled first, before we actually get trial dates, where the judge will ask us, attorneys, all right, Ms. Sweeney, how long do you estimate this trial? What are the issues? How much evidence you think you need to present? How much time you need for each witness? So we need to be very prepared, and we need to know what this is going to take. Sometimes we'll have forensic accountants who needed to be involved for a variety of reasons, and that can take a long time for their testimony. And sometimes we'll have many exhibits. Let's say you're dealing with reimbursements since the day of separation, and there can be many items that will need to be presented. So it just depends. So sometimes we can say, if it's just one or two simple issues, this is a 2 to 3 hour trial, Your Honor. I only have maybe 10 exhibits and only my client testifying. The other party may say, I still disagree. I think it will be a full day because I also am bringing another witness. So depending on what we present, they're going to give us trial dates. And I've had trials anywhere from 2 hours, and I've had trials that were 2 to 3 weeks, and sometimes even not done, and then you still have to get additional time. So there's no typical answer for this. Sometimes we'll split the issues and say, let's resolve these issues first, and we do maybe few days trial on half of the issues in the hopes that then the rest of the issues would settle afterwards. And sometimes they do, sometimes they don't. And then you may get a second trial, but it is hard to tell. And it really depends on the number of issues and how much evidence you need to present and how many witnesses.
Ellie, what do you find clients usually find is the most unexpected thing that happens or that they go through when dealing with a family court trial?
I think what clients find the most surprising and shocking is when they feel the other party is not being truthful. They find it shocking that somebody can sit and testify under penalty of perjury and not be honest and truthful in the hopes that that's not going to be discovered somehow later. That is one thing that is surprising. But being on the stand, I find a lot of times clients are, they get surprised by question from the other attorney, but you need to be prepared for everything. They have the right to ask you questions. I am the other attorney for the other party. I have the right to ask them questions. And perhaps sometimes I'm going to prepare things for impeachment purposes only. And they don't know that it's coming. And yeah, maybe it's a surprise, but it's fair game. So
Yeah.
try not to be dishonest, or otherwise you will be exposed potentially to impeachment.
Well, and the piggyback on the follow up is perfect because I'm sure those are stressful and emotional situations. So, what can help clients manage the stress and emotions of a family court trial?
I don't know the best answer to this because it is stressful. Imagine a client who has never been to court, never testified in any manner. And here they are, and they're fighting usually for very important things in their lives. We're talking custody of their children. We're talking support. I mean, it's their existence, potentially loss of home where they're going to need to move. These are very difficult issues, and they are hard for clients. And I understand that they come emotional, and I tell them, to just be themselves, be honest, be truthful. And if you happen to start crying, cry. That's okay. You're human. In family court, we always have tissues on the table because this happens quite often. But at the end of the day, I just tell them, you need to know it will be behind you and you'll get through it. That's the most important thing they need to know.
Ellie, before I let you go, I would love for you to give some advice out there to someone who's preparing right now for their initial family law trial, like you just mentioned, right? They got to get ready for the emotional stress that this could potentially cause. What would you advise them that could help them feel a little bit more prepared and knowledgeable heading into the situation?
In your testimony, be as clear as you can be. When you're asked the question, listen to the question carefully and answer the question. Many times they'll get a question and they'll say, well, I need to explain what happened before that. It's okay. We attorneys will get to that. Just answer the question. And of course, prepare your evidence. Prepare your evidence ahead of time. You don't want to be surprised and then regret later and say, oh, but I had a response to that text message and I didn't have a chance to present it. And then it's too late because we need to exchange our evidence usually a week before. So be prepared. Think of everything possibly that can come up. Even if you think it's too much, even if you think it may not matter, let me look at it. It might matter, and I'll decide.
Yeah. Ellie, thank you so much for the time and insights on this. We truly appreciate it.
Thank you, Mike.
And thank you to everybody out there for listening to another episode of Your Rights, Your Voice, Family Law Clarity with Ellie Sweeney. If you're facing a family court trial in California, preparation and guidance, like you just heard Ellie say, can make all the difference. Do me a favor, if you want to schedule a consultation, or learn more from Ellie, visit elliesweeneylaw.com. If you found this episode helpful, do me a favor, like, subscribe, review, share it with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.